Good evening, my dear MTBNs and others who have joined this webinar. Today we have a light panel of speakers who needs no introduction. Mr. Sankaranarayanan, Mr. Ramakrishnan and Srinath Sridevan. I thank them for promptly accepting our invite for today's discussion. Coming to today's topic, recent decision of Madras High Court on the tax liability during the CIRP period is of the utmost importance, seeing the present litigation. In fact, the High Court has dealt how the clean slate theory will be applicable during this period. We could not have asked for a better panel of speakers on this subject. In fact, Mr. Sankaranarayanan represented the revenue in one of the decisions. I request now Mr. Natarajan, who is our treasurer, who will monitor this session, to take over from here. I once again thank everyone who has joined this meeting. Thank you. Have a good weekend. Thank you.
Thank you, sir. Very good evening to all of you. Especially special thanks to all the 3 senior counsels who have taken time to be with us today. Just to give a brief introduction about the topic, all along, we all start with the Ghanshyam Mishra, where the decision was to the effect, once a resolution plan is approved, no liability which is not part of the resolution plan can be raised. See, earlier we were all under the sovereign theory, where the crown's debt, all the tax payments, they enjoyed the immunity like a crown's debt. It will be on top of it. But this IBC has brought a new norm to the field with a view to encourage entrepreneurship, making the process of reviving the companies more easier. Even if it has to be liquidated, the process has to be simple. How to maximize the value of the asset. All these are about objectives of IBC, which has made a complete paradigm shift over the approach. The government dues, that should also form part of, they should also stand in the queue. There is no priority, there is no crown's debt. They are treated as an ordinary operational creditor. This is a very major shift, but this has not been understood fully by the department. We have to say that the departmental officers, this has not reached completely. The department still believed that the crown debt theory will continue to hold the field, leading to a lot of litigations and all. Then came the Ghanshyam Mishra, which said that once the plan is approved, any liability which is not part of that plan will get extinguished. So that was interpreted and followed by several judgments. The amendment to section 31 of IBC was carried out to bring in more clarity. Even the government dues are also covered by the clean slate theory. For the first time, the Madras High Court had the occasion to further look deep into the issue. The period can be divided into 3. Prior to initiation of the CIRP, during the CIRP period when there is a moratorium, after the plan is approved, the successful resolution applicant, they will take over the management, they will run the affairs of the company. So there are 3 phases: pre-CIRP, during CIRP, post-CIRP. As far as pre-CIRP concerned, there is no doubt, the IBC is very clear. Any claim pertaining to the period prior to initiation of CIRP, it has to be lodged with the RP, approved, and then whatever is decided in the resolution plan, that alone they will get, the remaining will get extinguished. There is no doubt about it. During the CIRP period, when the company is functioning as a going concern, the management of the company is vested with the resolution professional. The resolution professional, under the guidance of the Committee of Creditors, they run the business. During that period, it is operated as a going concern. They are liable to make all statutory payments. Anybody who is supplying goods or services to that company, they have to supply, they should get their dues. The company will be run as a going concern. During that period, tax liabilities may arise. The tax liability, really there may be a tax liability, or there may be an issue of interpretation. There may be an outright case of evasion also. Of course, the RP is expected to do the business in compliance with all laws and regulations, but still a liability may arise during the CIRP period. Once the plan is approved, the management vests with the SRA, that is the successful resolution applicant. After that, there is no dispute. Anything happens in the company, it is only the SRA who is responsible. Pre-CIRP also there is no doubt. The only gray area was what will happen to the tax liability during the CIRP period. Whether the clean slate theory expounded by the Supreme Court in various decisions, especially in the Ghanshyam Mishra, will it cover the period during CIRP also? So, because if we go into the facts of all the cases which are decided so far, in none of the cases, the CIRP dues, that is the dues pertaining to the period of CIRP, that was not specifically dealt with. The final dictum of the courts was once a plan is approved, anything which is not part of the plan will get extinguished. So that has been interpreted to mean even during the CIRP period, if there is any liability, that will also get extinguished. Then what is the safeguard for the government? How they have to determine the liability? A lot of arguments were put forth. In fact, there are two judgments, one by Justice Saravanan, which was followed by Justice Shafiq's judgment. Justice Shafiq heard the matter for so many days. Every day the hearing will start at 4:30 in the evening, continue till 7:30. It was going on like that, and lot of hearings have taken place. In fact, our senior Mr. Arvind Pandian was helping the court as an amicus curiae also, and finally the judgment has come. And now the effect of the judgment, every stakeholder will have something to take from this judgment. How it will have the impact on the corporate debtor, what will be the impact for the revenue, what will be the impact for the committee of creditors, and another major area, even though we have not mentioned specifically in the topic, the major impact is going to be on the SRA. I don't want any one person to address that. That is why we have kept it open. All the three speakers will be addressing, because they are the ones who are going to bear the effect of this particular decision. What is going to be the effect of this decision on the successful resolution applicant? So all four parties from perspectives we are going to hear from our eminent speakers. So with this, I request first our senior advocate, Mr. Sankaranarayanan, who has also incidentally argued this matter on behalf of revenue. Sir, you can now proceed, sir, with your perspective from the revenue, as well as you can also touch upon the perspective from other angles also. It is not that it is limited to that, and no doubt you may have to cover the perspective from the successful resolution applicant also. Over to you, sir. Sankaranarayanan, sir?
It's 4:39 now. 10 minutes?
Yeah, you can take, sir. You can take more. There is no hard and fast rule. You can take even more also.
Thank you very much for the introduction that you gave, and how much I think 3-4 days after 4:30 till 6:30, 7:30, I had the privilege of arguing on the same issue. But to start with, though it is not the subject matter today, I have my own reservations prior to the CIRP also. I personally feel that a situation should not arise merely because somebody does not come and file a claim and he sleeps over it. The whole debt will vanish. I have my personal doubts. I'll reserve it for a better occasion. But it is now provided for in the regulation. The balance sheets are available. If a particular debt is seen by the resolution professional, it is my personal opinion that he must write a letter to the concerned creditor, ask him to file a claim petition and consider it while preparing the information memorandum. Leave aside. Coming to the CIRP period, the entire process is creditor-driven. Now, when the creditor-driven, the person who undertakes this task is the resolution professional. Not anyone can become a resolution professional. Only all those agencies which have been recognized can take that role. Now, therefore, he becomes virtually one-man director of that particular company to run the corporate debtor during the process. Any tax liability that is incurred, be it GST or income tax, which he incurs at that time, it is his responsibility to ensure that it is paid. He cannot pass on the buck to the committee of creditors or to the successful resolution applicant. And if he is negligent, the same rule that normally applies in respect of a director who has not paid, when there can be a personal proceeding against him, both under the Income Tax Act. Of course, Income Tax Act clearly says it's a private company. GST also provides for that. He must be proceeded with. This is the general background. On the question whether it is a CIRP cost or not, the issue can be very easily, though it has been considered by Mr. Shafiq, but the whole problem arises because how will the successful resolution applicant who comes into the picture know anything prior to all that he will have is the balance sheet 2 years preceding the CIRP date. That is all the contemplate section 18 contemplates, the regulations also contemplate. So prior to that, if something had happened and some amounts are due, there is no way in which the resolution applicant can find it out. But with regard to the currency, it is easy. You'll find it under section 30, under regulation 36 of the insolvency corporate resolutions. And if you go to the what it should contain, a very interesting clause appears in 36(2)J, company overview, including snapshot of business performance, key contracts, key investments highlights, and other factors which bring out the value as a going concern over and above the assets. Assets are there seen. These are all the factors which will push up the value. Assets of the corporate debtor, such as brought forward loss in the income tax returns, input tax credit of GST, key employees, key customers, etc. And he has to annex the latest balance sheet, the previous 2-year balance sheet, thereafter the latest balance sheet, up to the audited, if it is audited, if it during the current year, provisional unaudited balance sheet. With all these things, the resolution applicant can always conduct a due diligence and find out, because as far as that is concerned, you will get it in section 13. You will get it in section 31 if you look into of the code, which deals with the 31. 31A, sorry, regulations 31A. Information insolvency resolution cost also it's referred to. Amounts due to suppliers of essential goods and services under regulation 32. If it relates to amounts due to suppliers of essential goods and services, obviously it will also have the impact of input tax. Therefore, there is something that is available in the record for him to do the due diligence. Now, if he does not pay, the resolution professional for the period when he gives you a unaudited provisional balance sheet for the current year, one will be able to find out what is the amount due. Then the resolution plan must definitely provide for that money. And any resolution plan which does not provide for that money, if approved, would be contrary to the law, existing law, will be in contravention of section 31 and also 61. In an appeal, there are 2 grounds available. One is that is in conformity with law. The other is material irregularity. It will be contrary to law because there is an amount available. You know that the money is payable, and yet that amount resolution plan does not contain any provision for that, on the only ground that has probably they have not filed a claim at that time. During CIRP, there is no question of receiving a claim. It is only prior to CIRP. Therefore, when a person's GST is a pass-through, income tax may not be, but ultimately, the provisional balance sheet will show what is the money that is earned and what tax is due on that date. On that particular date can be calculated. At least a provision can be made. If the professional fails to do it, there is a negligence on the part of the professional. The same yardstick that one would apply to a director who is negligent in not paying the money has to be applied to the resolution professional also. He cannot simply say that ultimately I got out. I am after all an agent for the COC. The COC will pay. It is not the job of COC to pay. Similarly, when resolution applicant is concerned, he is also not liable to pay this money. Provided, if he had seen all these things in the provisional balance sheet, then it is his duty to deal with that and say, I am going to pay it, I am not going to pay it. The way it is put, all these judgments, if you look into it, they say whatever contained in the resolution plan has got a role to play. But resolution plan, by simple, better drafting, cannot exclude a tax liability for the simple reason, ultimately the country has to run from the revenue. If the revenue is going to be treated in that particular manner merely because I have not made a claim and you will lose it, for the CIRP period, then it would mean that the resolution, the professional is in a better place than the corporate debtor being managed by a person who failed to discharge his debts. And that is why the present situation arises. He cannot be in a better position. He is the same person. Whatever the director was required to do, this man is required to do. And if he fails to do, he is personally responsible. The only other person who can probably be held responsible would be SRA, though it is rather incorrect to say that he has to bear this burden also, but he has to take necessary care to find out the latest balance sheet and conduct a due diligence before he prepares a resolution plan. At least he must exclude. He must say that there is an amount payable, but this account does not show me the correct position. That is why I am unable to provide for it. Then COC will consider, they will know what kind of plan. Virtually a provision of the Income Tax Act would be rewritten. Now, therefore, that is one more gray area that we find. I think my 10 minutes is over. Thank you.
Sir, anything is left or you can please continue. I can.
No. I'll come back. After some
we can
time,
come
I'll
back.
come back.
It's all right.
I thought I'd give a gist so that this is what I personally feel. I am more concerned about the possibility of a proceeding of an escaped assessment coming after the CIRP period. That gray area has to be filled up. There are only one thing which I have understood. One of the sources of mercantile law is what we call as a law merchant or a trade customs. That is one of the sources of mercantile law. They say the merchants find out something, law comes thereafter. This is what the original English law prescribes in its textbook. The same thing is applicable. We can see the derivative contracts which shook this country in 2006-07. I'm sure Srinath has conducted 100,000 cases in the derivative transaction that period. The merchants found it, law came later. Everywhere the merchants find it, law comes later because they are on the business. They know what is happening on a day-to-day basis. Therefore, it is absolutely necessary that it is the business bodies, the professionals must consider this, pass a resolution, and next time when the IBC is amended, then most of these things must be provided for. Everything cannot be left open for a particular as a gray area, considering the fact that time available for these tribunals to consider lengthy arguments is very, very limited. Most of them are not willing to even hear that. It will create a problem and it will ultimately go back to the same situation where we were when SICA came, BAFR came, AFR came, even under the Sarfasi Act, they can take the same action could have been taken by the banker under, I think, 14(1)(a) or so. They can take over the management, appoint somebody else. All these things could have been done. And more, these laws should not be converted into the same position where it was 30 years ago. The best way is to bring proper amendments by having some kind of an empirical research to find out how much money the revenue has lost in the last 6 years in the resolution plans on account of the CIRP cost and reassessment process. And that should be a wake-up call to find out how best to fill up the loophole. At the same time, there has to be an act of balancing. And in the act of balancing, TOC, after doing all these things, they should not lose more money than what they have already lent. And the successful resolution applicant, he should not be asked to deal with a bargain which he never intended to do. Therefore, this act of balancing can take place only with facts and figures, not a block sum saying so many companies went through under resolution, so much money was collected, bank has gained so much money. It is good for parliament, but not for individual clients. We need to discuss and find out how exactly it works. And only when we know how it works, we will be able to tell them that these are all the amendments required. Thank you.
Thank you, sir. Very thought-provoking. To put it in one word, you have emphasized, to borrow the same words of Justice Shafiq, Kavi Tempter. The SRA who is coming up and buying the company should be vigilant enough, and he should see what could have been the tax liability during the CIRP period, take that into account while giving the plan. So that is the crux of it which we have taken. So if we see the judgment, on the one hand, the judgment addresses the issues. If somebody is committing an outright evasion, collect the tax and does not remit it, take some fake input tax credit during the CIRP period, how can he go scot-free? Of course, it's a very valid point. At the same time, we should also look into account those type of evasions or outright non-payments or fake ITC may form a small percentage of the various demands. We practically see day in and day out the kind of demands being raised, the artificial demands, high-pitched assessments. When such be the situation, how the SRA can be expected to be vigilant against such demands is another issue which we have to think it over. As you rightly observed, there is a lacuna, there is a gray area, and the court has tried its level best to provide some kind of a solution to address the gray area, and beyond that, it may be the duty of the parliament to step in and try to do. With this, now I request our another senior advocate, Mr. Ramakrishnan from Delhi, to share his views, specifically with reference to the perspective from Committee of Creditors and, of course, SRES too. Yes, sir. Over to you, sir.
Sir, I am the COC, sir. As usual.
Oh, you are COC.
No,
Sorry for
I don't see there will be a
corporate
difference in viewpoint depending on whom we appear. That's in the court. Outside the court, I think all of us will speak the same voice.
Sorry for the interruption, but normally COC without Srinath Sridevan may not be in the fitness of the scheme. That is why. Please proceed, Ram.
Yeah, I have a different take on this. Let's start with very basics, not the judgment. Why did IBC come in? I've been practicing, and Sankaranarayanan has been practicing in the 1956 Act. It was terrible. Properties were locked in litigation before the liquidator for decades. IBC came in because they wanted a quick resolution of insolvency process. Large amounts of funds were kept outside business, locked up, deteriorating. This had to be resolved. There was a balance between taxation, claims, and utilization of scarce resources of liquidated companies or companies in CIRP. The balance was struck by saying, look, there's a claim, make a claim. If you don't make a claim, you're lost. This is true for private creditors. It's true of governmental debts. This was a background for the IBC. It was a new concept. It seemed to all of us that a lot of dirty linen, dust and dirt was swept under the carpet, and then the carpet was shifted out with the concept of a clean state. So this is the cultural shock which we face. The Supreme Court has meant boldly and said it's a clean state, tabula rasa in Latin. That's how it is. Now, take these two judgments, which I feel have not covered all aspects. These two judgments say Ghanshyam Das SR deal with pre-CIRP. They are not precedents for post-CIRP, and post-CIRP dues have to be decided afresh, and by the SRA, he takes it. It's a gamble for him. This distinction between pre-CIRP and post-CIRP is something I completely agree. Resolution plan covers pre-CIRP, not post-CIRP. But where I differ from both these judgments is splitting of the taxation dues. They have all taken taxation dues as the date on which it is payable, assessed and payable. And the payment date, they say, is post-CRP, and therefore it goes out. I have a different take on this. Forget IBC for a minute and take any standard taxation law. Take income tax, for instance, 2025 Act, similar to the earlier Act. The charging section decides the liability. The liability to pay income tax arises during the previous year or the taxation year in which the income is earned. The date of payment of liability, crystallizing of the amount of liability may take a long time. Assessment order, appeal, tribunal, up to the Supreme Court. It may take a decade before the amount is crystallized and the demand is upheld. But the liability to pay begins at the taxation event, date of taxation event. This is for income tax previous year, taxation year. Take GST. Taxation event is the date of the supply. The liability starts on the date of the supply, liability to pay tax. The due assessments, amount recovery, so it's liability, taxation charge to tax, then assessment, appeal, and recovery. We cannot confuse the date of filing the return, the date of assessment, and the date of recovery with the date of the liability to pay tax. Now, I'm going to share the definition of claim. This is the taxation concept. In both these judgments, the focus was on the liability, crystallizing of the liability by the assessment and the demand notice leading to recovery. This focus, I submit, is wrong. Now, I'm sharing, one second, the IBC with you. Are you able to see this on the screen?
Yes, sir.
Okay.
Yes, sir.
Here is it. Definition of claim. Claim means a right to payment, whether or not such right is reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured, or unsecured. The right to payment commences on the occurrence of the charge event, taxation event. In both these cases, the taxation event, let's take the first case for instance. This is Justice Taravanan's judgment. Assessment year 2018-2019, previous year was a year before that, which means the taxation event, earning of the income, took place before 31/3/2018. The demand of 9 crores arose on 31/3/2023. The resolution CIRP commenced 2018 and the resolution plan was approved 2019. This, my submission is, falls within the definition of claim. It is a pre-CIRP liability. If it's a pre-CIRP liability, then the difficulties which Mr. Sankaranarayanan pointed out from the SRA's stage fails into insignificance. The SRA cannot be expected to take a gamble on the bid. Now, if he takes a gamble on the bid, he will be bidding very, very low. And that will be against the maximization of yield contemplated by the IBC. He cannot guess from thin air on what a demand would be in the future years to come. Let's say this 148 notice and the demand was 9 crores. That can go up on appeal, that can go up to the tribunal and back and forth, because IBC will not interfere with the quantification of liability. Now, if my submission is taken into account and you define claims as wherever the taxation charge event took place before the commencement of CIRP, then this issue is resolved. There may be a supply, for example, there may be a supply of goods or services after the CIRP commenced. This supply will be in the books of the RP, and this will be transparent. Everybody will know that this is a supply. This supply, taxation event which occurred after the commencement of CIRP, after the RP was appointed, will be costs of liquidation or costs of CIRP. Nothing else other than that. If this approach is taken, this will be in consonance with Ghanshyam Das, because in Ghanshyam Das and SR also, the taxation event took place prior to the CIRP, although that was not argued, I agree. What was argued there was both taxation event and the demand of tax, assessment, crystallization, and the recovery process. These were prior to the CIRP. But I'm saying claim, as defined, as I shared, will be pre-CIRP in both these cases. Now, let me move from that issue. And here, Mr. Sankaranarayan's suggestion, I completely agree. There would be, it is not necessary to amend the IBC. It is enough to provide in the rules or the regulations that the RP must write to every person whose name arises in the creditors list in the balance sheet. RP must also write to all the statutory authorities, let's say a handful of statutory authorities, direct taxes, indirect taxes, not too many there, write to them inviting claims from them. This will take care of the revenue's interest, because the revenue cannot keep track of every claim happening throughout the nation. Okay. Then let me come to Mr. Sankaranarayan's suggestions appearing for the revenue about the loss of revenue. Now, this has also been considered to a certain extent by the legislature. I'm sharing with you the recent amendments to the IBC, where there is a systematic dismantling of crown debts, taxation dues, and priority given to recovery of taxation dues. I'm sharing the 2026 amendment to the IBC. Please look at the definition, explanation given after clause 31. For the removal of doubts, it is clarified that security interest shall exist only if it creates a right, title, or interest or claim to property pursuant to an agreement, arrangement, act of two or more persons, and shall not include security interest created merely by operation of any law for the time being enforced. This is a clarificatory provision. Once it is notified, it operates with retrospective effect. Let's go to the select committee, which commented on this amendment. The select committees referred to the reasons justification given by the Ministry of Corporate Affairs for the proposed provision. Section 3030 of the 330 defines security creditor, and in the state tax officer versus Rainbow Papers, so and so, Supreme Court interpreted the definition to hold that any governmental authority shall be a secured creditor. They wanted to get over this definition. And this is the reason for the amendment. So systematically, the concept of state taxation debts priority has been eroded. And where does it leave the taxation authorities? They are not worse off, because the sooner this company, which is insolvent, which is in CIRP, starts earning, the more revenue they will recover from the new business rather than flogging a dead horse. This is my take on these. Over to Srinath. Thank you.
Thank you, sir, for the exhaustive analysis. You brought the fine distinction between the tax liability, which is just determined during the CIRP period, and the tax liability pertaining to the CIRP period, and the different approaches that have to be applied for both. Now, I request Mr. Srinath, Sridevan, Senior Advocate, to join.
Thank you. At the outset, thanks very much to MTB for giving me a platform to rub shoulders with two giants whom I admire greatly. I feel like the person batting after Tendulkar and Dravid, and so let's hope I can score a few runs at least. The main approach to interpreting the IBC, and Ramakrishnan sir did touch upon it. Both honorable judges have used fairly standard modes of interpretation of statutes. Justice Saravanan took the strict interpretation, which is a very well-established principle, whereas Justice Shafiq took the purposive interpretation, and they reached the conclusions that you've seen in P.G. and Aquaterra. I'm going to now read the opening paragraph of Torrent Power, which is the latest judgment of Her Ladyship Justice Nagaratna. Neutral citation is 2026 INSC 206. So she tells us how we should interpret the IBC. She says, The IBC marks a fundamental shift from a court-centric model to a creditor-driven process. At its core lies the doctrine of commercial wisdom, a conscious legislative choice to vest decisive authority in the committee of creditors, comprising financial creditors who bear the economic consequence of failure. IBC recognizes that decisions on viability, valuation, acceptability are inherently commercial and not judicial. Therefore, I've always been a bank lawyer. So for me, banks look for certainty. We need to know how much money we can write off from our books and how much money we can retain with a reasonable certainty of recovery. So I don't think we should look at it from the lens of what is fair to one stakeholder, what is unfair. We should look at what is the best way in which we can move forward. And Shankar sir rightly said that I would like to have a study of how much has been written off in the course of various assessments which have been lost and reassessments which have been set aside. But from the bank side, a study has been done on how much we lose by way of haircuts and how much we gain by way of the operation of the company continuing and the commercial activity restarting. And these studies have shown that we are better off taking a haircut in the short term for a much more long-term return, which we will realize. And I'm reasonably sure the same reality should exist on the tax side also, but I don't have the empirical data for that. So going to the two judgments, I think Justice Saravanan, took the strict interpretation. He says, I don't see anything in the IBC. And as Ramakrishnan sir rightly said, the IBC as it stood prior to 6th of April to justify excluding pending CIRP or pendente lite tax dues. Whereas Justice Shafiq, I thought is a remarkable judgment. I mean, it's a very nuanced approach. He looks at section 17(2)(e) of the IBC. He says, the resolution professional is in charge of keeping the company operating as a going concern. And he also says, I think paragraph 13(1)(f) or something, he says that if there is a fault to be found for not filing returns, it's on the RP. Who's the RP? RP is the officer appointed by the court, the NCLT. So now why are we talking about the department taking haircut or the SRA being made a scapegoat? We have here clearly a limb of the sovereign judiciary and the tribunal functioning under that, and the tribunal having an officer who is failing in his or her duty. I think it should be reasonably easy to figure out how to fix responsibility for failure to file returns for that period. There's more to say about this, but I quickly want to touch upon the amendment. I'm grateful to Ramki sir for talking about the clarificatory definition to 30, which undoes the substratum of rainbow papers. So there's a clear legislative thought behind saying that we don't agree with rainbow papers. That was not what we intended at all. But there are two further sections which I think make the debate, which is subject matter of Justice Shafiq and Saravanan's judgments, only academic. And for those of you who have the 2026 Act, which was passed on 6th April, please take a look at section 19(e) of the Amendment Act, which amends sections 31(5) and 31(6). And 31(6) says, and I'm going to read 31(6)(a), where the adjudicating authority, that's NCLT, approves the resolution plan, unless otherwise provided in the plan, any claim against the corporate debtor and its assets under any other law for timing in force prior to the date of approval shall be extinguished. And B, they've gone even more emphatic. No proceeding shall be continued or instituted against the corporate debtor or its assets on the basis of such claims, including proceedings for assessment. So assessment, reassessment, everything is knocked out. So legislature on 6th April has said, okay, on and from this date, if there's a plan, everything prior to plan, including the failure of the RP. And this was something which has troubled both Justice Shafiq and Shankar sir, because, how can you get away with failing to comply with a statutory duty and then just telling the department, too bad, what to do? So there's something here which is troubling. And so what's the answer to that? There is one judgment of the Honorable Supreme Court. It's a 3-judge bench. It's called Sundaresh Bhatt versus ABG Shipyards. It's 2023, Volume 1, SEC 476. So that was a case where the gratuity, so the companies operated during CRP, the workmen keep on working. The RP doesn't remit gratuity, doesn't remit PF. And then when the company finally goes into liquidation, as usual, department people are either too great or too busy to do anything on time, so nobody files a claim. And so when the workmen finally turn up, there's only an empty shell left. And this reaches the Supreme Court. And a 3-judge bench in this Sundaresh Bhatt, they say some very interesting things. It's something like what Justice Shafiq was troubled by so much, and you can see some echoes of that. They say, if the workmen have been working throughout and their work is essential for the company to remain as a going concern, is that not a CIRP cost? Because once you're a CIRP cost, you go to the top of the pyramid, you go even above the banks. So they say that the workmen, if you are working to keep it alive, shouldn't you be a CIRP cost? And Justice Shafiq kind of hints at this. He goes very close to this, but then of course, he leaves it open and remands it back. He says, you have a registration under GST Act. You have a duty to file your returns to keep that registration alive. Isn't that duty part of an essential activity to keep your company a going concern? To have that registration alive for the GST department or the income tax department, is the continued registration not part of it being a going concern? And he also talks about the breakage of the ITC chain. If pending CRP, the resolution professional doesn't pay the ITC, what happens? There's a break in the chain. So Justice Shafiq it's a beautiful judgment, because you can see how much agony he's gone through. He's seen the various angles, and he's sent it back. He said, you please find out if you can fit within CRP costs. And Shankar sir did read this to all of you. When you have some free time, take a look at Regulation 31 of the Insolvency Resolution Process for Corporate Persons Regulations, and take a look at the various subclauses in 31. And in my opinion, 31E says other costs directly relating to the CRP process, which of course should be approved by the banks. And maybe there we need to do some creative interpretation. But if you can fit into CRP cost, then that may be a way in which everyone's concerns are resolved. Because one, the tax department is not deprived of its pending CRP dues. The SRA is not saddled with something because he sees a flat amount in the CRP cost and he knows he's got to provide for it. And so his bid factors that into his calculations. The banks don't have to take a haircut because we know what's sitting on top of us. Now, what does this need? This was also considered by the Supreme Court in Sundaresh Bhatt. It was one of the very few judgments where I've seen the Supreme Court actually haul up in that case, the Provident Fund Department. It says, you have to submit your claim within the timelines. You can't just sit in your air-conditioned room and make your assessment after years. Be alive to CRP timelines. You do your determinations. Of course, the RP must file his returns, but you make your determinations. If it's a best judgment, so be it. And you submit your claim. And once you fit into CRP cost, you'll be right on top of the pyramid. And speaking for banks, if we don't like suppose if Shankar sir makes an assessment for a high-pitched assessment for 100 crores, the COC can take a call to appeal it. Of course, that will then have its own repercussions, but at least everyone goes into the process with total certainty of possible spectrum of outcomes. So this, I think, after the amendment, of course, the only thing which remains is the duties of persons pending RPs and accountability for breach by RPs. And in the UK, I saw two amendments which I think we could profitably gain from. One, they've recently brought an amendment for personal liabilities of the past management for misuse of insolvency provisions. It's beautiful. So what they say is Her Majesty's revenue or His Majesty's revenue will proceed against the directors personally if we find that the company has gone into insolvency, leaving huge tax dues by any breach of yours. And every insolvency is going to be only because of the breach, some breach by the directors. So again, the revenue is not left high and dry even for past dues. That was one interesting thing. Second thing is there they don't have a resolution professional. They have something called an administratorship. So they have a provision in the tax code for filing of returns by the administrator and assessment pending administratorship. So it doesn't take much effort to find a way to provide clarity and certainty to all the stakeholders so that the IBC doesn't become a one versus the other dynamic. It becomes a smoothly cohesive thing where the creditors can drive it for quick recovery. And, as Shankar sir said, not go back to the old Sika days where case will be pending for decades. That's all from my end. Thank you.
Srinath, may I make a request? I will share section 19. Can you just walk the audience through that?
Of course,
because
sir.
you made a very important point
Yes,
on
sir.
the 2026 amendment, which I think what you said conclusively sort of legislative overrides these two judgments.
sir.
I'm sharing it is section 19. This is where it starts. The next page is section 6. I'll wait till Srinath takes the audience through this and then we'll move on.
Yes, sir. So this is the new subsection 6 to section 31. It is part of section 19E of the Amendment Act. And hereafter, once it is notified, where the adjudicating authority approves the resolution plan under 1, which will be 31(1), unless otherwise provided in the plan. So some good Samaritan, like a company belonging to Shankar sir, unless the company is there like that, any claim against corporate debtor prior to date of approval shall stand extinguished. And B says you can't do assessment also. The explanations talk about the guarantor's rights. That's really, I don't think it matters. Explanation 3 kind of makes it clear that it's prospective in nature, which is also, of course, very understandable. But yes, 31(6)(a) and B, which come under section 19E of the Amendment Act, are as, to use Ramki sir's language, are determinative. And we should bear that in mind going forward. Of course, since it's prospective, there'll be a multitude of cases, past cases, where we will need to still apply either the strict rule of Justice Saravanan or the purposive rule of Justice Shafiq or maybe a third view which may come out in future. Thank you, Ramki sir, for sharing. So kind of you, sir. Thank you, TMTV.
Thank you, sir. We have deliberately kept you as one down after Sachin and Tendulkar because we know that you are Vaibhav Suryavanshi and you approved it to be. And now the floor will be open for questions. And I should thank all our disciplined audience. No audio, no video or nothing. In fact, in other words, no Hydra head has propped up during the course of the entire 1.5 hours. So people were so disciplined and they were waiting. So now you can unmute yourself and you can shoot your questions. If you want answer from any specific speaker, you can say so. Otherwise, it will be answered by any one of them. We will spend some time on question and answers.
Can I go ahead, Natarajan?
Yes, sir. Yes, sir. You are one of the person who argued before Justice Saravanan. Yes, sir.
Good evening to all of you. As Natarajan said, I had the privilege of arguing the P.G particular case before Mr. Saravanan, and I had to face a lot of questions which I thought I was able to answer. But like what you have stated, prior to CIRP, during CIRP, after CIRP, we all talk about that. But whatever amendments you are talking about now under 31(6) is exactly what is reflected in Ghanshyam Mishra para 102, the third para or something, where they very clearly say for the date prior to the approval of the resolution plan. See, one is the date on which the CIRP starts, there is an interregnum during which the entire thing goes on, and finally the resolution plan is approved. And Ghanshyam Mishra is not saying that for claim before the date on which CIRP is initiated. No, they don't say that. They are clearly saying with reference to claims which are arising before the date of approval of the resolution plan. Therefore, I was pointing out in that particular case, it was in July 2018 that the CIRP started, but the resolution plan was approved somewhere in October 2019. And we are talking about an assessment year 2018-19, for which the previous year is 17-18. CIRP itself started after 17-18, assessed previous year ended. No doubt, there is still 6 more months to file the return, and there is still more time to assess under 143(1), and all those things may be there. But the fact remains, not only based on Ghanshyam Mishra, that was the interpretation of 10 other high courts with reference to where, and I took very specifically cases in which the demand was during that particular period and which were all dismissed by the Supreme Court on merits, not only as a SLP dismissal. But despite all that, I think the view that is being probably taken is 18-19 assessment year, but then we are confused 17-18. This is a previous financial year. After that, only CIRP itself has started. Therefore, there is nothing like, I would say, 3 different periods. There are only 2 periods. What is the period preferred before the approval of the NCLT president plan? What is after? And then, right, like what you have pointed out, during the interregnum, of course, during the operation of the company during the interregnum, everything precedes that particular view. Therefore, while there could be, but actually, I also had this particular doubt when I got admission for this case before Justice Krishnan Ramaswamy also. How could the department even know what will be the demand for 2018-19 assessment year till the date for filing the return comes, and thereafter whether the assessment is summary under 143(1) or there is a scrutiny under 143(3), which takes place much later, etc. But the overall free feeling means IBC should not give something which is not contemplated by the person who is taking over. Otherwise, this entire IBC would also become a failure. That seems to be the overriding factor, as seen from any number of these decisions. So to that extent, I felt that I have still not been able to get into facts each case of Mr. Shafiq. But because P.J. argued, there the dividing line, according to me, was very clear. So I just wanted to know, is there any point which I am missing in this, so that you can give me your input on that particular aspect? That's the only thing. Grateful.
My suggestion is you might want to develop the taxation event. If the taxation event takes place after commencement of CIRP, it's a part of CIRP costs. If the taxation event takes place prior to CIRP, it is not, it is a previous claim. Now, your question is how will the department be able to assess the tax because it doesn't have the return before it. I think what the department should learn to do is, if Mr. Sankaranarayan's suggestion is adopted and the RP is bound in duty to write to all these authorities, then they will respond giving their best judgment figure for the claim. It may be right, it may be wrong. They'll just give the top of the head figure, best judgment, and file a claim for that. Now they are no longer secured creditors, and this amendment comes in, they are in greater trouble. But question is, the amendment cuts both ways. One can argue because the amendment came in with an express language, it indicates legislative intent to the contrary previously. What is expressed now is made express because it was not the law earlier. That's one interpretation. The second interpretative canon is you cannot use a subsequent amendment to interpret the language of legislature which was there prior to the amendment. So these are two things. I think you might want to develop the taxation event, charge to tax. That you could develop and say that's within the CIRP.
This, I may just add one thing, but sir, actually, Section 18 very clearly says you'll have to find out the viability. IRP is bound to test the viability. Financial position. You will understand the financial position only if all the assets and liabilities are known. 6A regulation was introduced in the Insolvency Corporate Persons Regulations, 6 capital A. It says the interim resolution professional shall send a communication along with a copy of the public announcement made under Regulation 6 to all the creditor as per the last available books of accounts of the corporate debtor through post or electronic means wherever the information for communication is available. I take it that there will be some provision made in the balance sheet with regard to the income tax. If it is sent, the income tax department may wake up and file a claim at least. The point is, 6A was introduced only to ensure that merely because somebody sleeps, one should not steal away with the property and go say that he did not come, therefore that is written off. That appears to be once the moment comes, thereafter if the revenue decides to sleep, nobody can help them.
In fact, surprisingly, here they came up with all the claims up to assessment year 2017-18, but did not make the claim. For 5 years, they gave the data in the resolution plan, but did not make the claim. For 18-19, they have now come after this. That is one of the problems. And the whole problem is, we see the problem. The auditor himself said, we don't have any data, we don't have any audited data. So it is only after all these events, now I come to know that some 15 crores money was withdrawn, 15 crores was deposited, cash, etc. None of this, as a taking over person, I will not be able to answer at all. That is one of the difficulties which we are facing in that particular case. Any case. No.
But will it really affect you? Because after this retrospective amendment is notified, definition of creditor, secured creditor, and the state is no longer a secured creditor, it doesn't matter to you. They're not going to get anything.
Yeah. No, they are not going to. But then, because of this, of course, unless it is set aside in the appeal or further, etc., then the department will issue notices, continue with their 148A.
No, they will not be able to. They will do all that, but they will not be able to recover the money from you when the retrospective amendment to secured creditor clarificatory comes over. So it will be an exercise in futility.
In fact, that was one of the reasons the department argued. We are keeping all this open in order to go after the X12 promoters and directors who have made all that. But then those got sidetracked, because we are examining only the question whether this would form part of the resolution plan or it will be out of the resolution plan. That was the only question which was answered in this case. Thank you, sir.
Thank you, sir. Any other person would like to raise any query?
Sir, may I make one a humble request to this luminaries of law and before this established legal professionals? I just wanted to ask one quick query. This recent amendment to this IBC 2026 from 6th of April, it makes in section 31 very clear that any concession or any kind of approval which has been given to a corporate debtor cannot be terminated, cannot be discontinued for the reason of insolvency, provided that current dues are being paid by the company. In fact, it is giving a very good kind of an exemption that authorities, particularly regulators, sectoral regulators, should not disturb the company's operations. And I have seen recently, sir, the Supreme Court has come out in Spectrum Law, a kind of a decision. I think it is the judges presided over by the bench presided over by Narasimha, Mr. Justice P.S. Narasimha, and a similar kind of a judgment also has come in another matter which involved Benami Act. But coming to the sectoral regulation of spectrum laws, they said that IBC cannot intervene in a law where the sovereign action has been taken. So just because this DOT, that AGR dues can be swiped off by the IBC by way of an operational debt, the company cannot go to another successful resolution applicant. The dues have to be paid. Spectrum is a national resources of every common man. So directly, I think, sir, this IBC's provisions, I'm really surprised that 6th April amendment, it says again that any concession, any benefit, any license, any permit given cannot be terminated. That's the kind of a wordings in recent section 31. It goes directly against this recent order of Supreme Court. May I request the legal luminaries here whether this kind of contradictory decisions by the forums, this amendment actually nullifies Spectrum, not only that, Rainbow Papers, Vidarbha Power, all these kinds of judgments given by the Supreme Court are set right by way of an amendment. So I request the views.
I'll take that. I'll take that. So I think we're talking about two very different things. It's a great point you're making. Okay. So first is the State Bank of India judgment, which deals with spectrum.
Yes, sir.
Then you have the bankruptcy, Benami case, where the Supreme Court has taken a contrary view to what Justice D.R. Swaminathan took sitting in Madurai. Then you have embassy. Okay, so there's a class of cases where the Supreme Court is saying that where the sovereign is exercising sovereign rights in relation to a sovereign asset. So now you're talking about spectrum, you're talking about mineral rights, which is embassy.
Embassy, correct.
Okay? So this is one category. Then you have the sovereign taking rights, taking action in relation where the statute. So, for example, if you take the Benami Act, okay, there is a statutory vesting.
Correct.
Now, Justice Swaminathan took the view. I don't remember the judgment. I'm sure you'll all know the judgment. He took the view that a resolution plan will wipe out the bankruptcy proceedings. Okay, I was troubled by the judgment, and Supreme Court, I think, has said that under the Benami Act is a statutory divesting. So there's no question of that asset forming part of the estate of the corporate debtor. So that's the second category of cases. Then you're talking about the fiscal dues, which is rainbow papers.
Correct.
So I think the three are very different. What this amendment does is it says that if someone has paid the dues, so long as they've paid all the dues, so long as they've complied with the conditions, to use the wording of the section, you can't cancel their registration. You can't cancel their license. You can't cancel their permission. But let us say the previous management had illegally mined,
okay,
or had obtained spectrum through improper means. It will be a travesty to say that the central government is devoid of power to deal with a natural resource like spectrum or let's say uranium simply because we've got a plan running on the side. I think this amendment will not affect the running of those judgments. That's my view. And the efficacy of whether it's embassy or SBI or the Benami judgment, I think is unimpacted.
In fact, sir, just to add on to whatever you said, I fully appreciate your views. Consider a situation. In fact, I was part of one of these judgments of Supreme Court, being a liquidator of a company. In that case, the banks have lent money exclusively on the mortgage of these properties. And these properties had nothing to do with the Benami Act, which happened much later. And Honorable Supreme Court probably did not differentiate these kind of issues. They said simply that under Benami legislation, there is a complete kind of forums are there. Adjudicating authority, appellate authority are there. You go there. But NCLT and NCLAT, even if the company is under IBC, they don't have the right to determine whether it's a Benami transaction or not. So that's the differentiation they made. That's very good decision. But then the banks stand to lose now, having lent money on the security of these assets, and the Benami transaction happened between the shareholders of one company and another purchaser of these shares in that particular case. So they didn't go into these details. My simple kind of a concern, sir, a lot of decisions come from Madras High Court has dealt with Justice Sai when he was here. He was completely vocal against IBC. What kind of law this is? What kind of provisions? Operational creditors are not even considered as legal citizens of this country. They are just thrown out in IBC. All kinds of things were there, and Justice Seshai is now in NCLAT as a member now, judicial member. And definitely we are looking at some kind of consistency. When a company is taken on a clean slate, the purchaser is not liable for any past baggage. Am I right, sir? So the action should go against the persons who have committed the mistake, non-compliance or offense. So that is why Section 32A came. 32A was...
I'll just quickly answer and then pass it on to my seniors to add to provide their wisdom. Speaking as a bank lawyer, we are before the PML80 very regularly. It's not like we are strangers to this. Where we feel that a particular mortgaged asset, secured asset, is not Benami or is not proceeds of a crime. We fight it out. It's not like we are helpless. So I don't think we need the NCLT to act as a shield to somehow get the property back for us. And there is some wisdom in the Supreme Court saying that the NCLT can't be a one-stop, I'm not going to call it a one-stop shop, but a one-stop laundry where everything gets whitewashed. That's dangerous. I'm going to request my seniors to add to what I'm saying, though.
Sir, the particular judgment where Benami came, I argued before the NCLT. For the first time, the matter came up under the Benami Transaction Prohibition Act that related to, anyway, Shashikala.
Yes, sir.
But that matter, see, ultimately, all that we said was, Srinath put it, I said that you'll have to go to a different forum.
Yes, sir.
If you try to do everything in NCLT, the NCLT may decide to pass assessment orders in income tax and GST. When will they take up our company petitions? And the two is in a very lighter vein. If there is going to be an absolute corrective, where will Srinath, I and Ramakrishnan will go?
True, sir. My point is that Section 32A provides even continuation of that investigation, taking them to task under the provisions of law, the person who has done the crime. But why not allow the asset? Now the asset is languishing. The asset is not going out of the hands of the liquidator, nor it is taken by the income tax department. Income tax department doesn't know where the asset is there, or they don't do anything on the asset. They don't securitize. They don't put any security guards to see what is happening there. It's all like, when a legislation of character of IBC with a huge kind of objective of reform and releasing unproductive assets, the attachments now come and probably, sir, it's my humble submission being an insolvency professional, but I really appreciate the views of learned seniors, sir.
No, I just take on from what you have said. I had appeared in two matters where there was a conflict between IBC. I was appearing for the liquidator, conflict between PMLA. Properties which are sought to be sold by the liquidator were attached by the authorities under PMLA. So question was, why should one of these solutions we proposed was, as you said, let's sell the property, let the money come in, and then you decide let's not hold that up. But this the bench, it came before Justice Oak bench, and typical of every court, the bench was in my favor, and the ASG took repeated adjournments till the judge retired. So it's not come up for hearing.
Oh my goodness.
Not only you're getting an answer to tax question, you're also getting a strategy session.
I think we can take one more question, one more last question, if anybody wants to. I think there is nothing more. Maybe to summarize, these judgments they are certainly going to open up a national debate. So true to our tradition of Madras High Court, these two landmark judgments will open a debate nationwide. And really, there is some gray area, there is some to be filled up. See, the one basic thing is the department also should realize that IBC is a special provision. They should not wait. Normally, any tax proceedings, it takes almost 10 years to get settled. But they have to be on their wheels. If at all any tax liability, it has to be determined immediately on a best judgment basis or whatever it is. And personally, I feel something more could be done. Maybe the NCLT, the adjudicating authority, may evaluate the claims through an expert body and incorporate it in the resolution plan. Whatever is the liability, it is not only it's going to be determined by the department, let it get validated by an expert panel to be appointed by an NCLT, and let that be made as part of the claim so that the issue could be resolved to some extent. That is one of the suggestions which is coming to my mind. With this, it was a great session, a very engaging session, and thank all the speakers. And now I formally invite our Secretary, Mrs. Maithili Madam, to formally propose the vote of thanks. Sir, Mr. Chopda, sir, anything you want to add?
No, you can kindly. It's all
yes. Maithili Madam.
It was really a fantastic session. Thank you very much, the esteemed speakers, senior counsels, Mr. Sankaranarayanan, Mr. Ramakrishnan, and Srinath, Sridevan. Each of you gave a different perspective on an already extremely involved subject, and it's thrown up more questions in our minds. It's been highly, and ultimately, whether we are looking at balancing trying to achieve the objective of the IBC, and at the same time, tax dues are collected as they should be, where they are due. This is going. The saga will go on, because unless the tax authorities are probably, a thought that comes to my mind is whether they could have a third system whereby, even if they are not vigilant about making their claims, they could probably come forward, and they could be called upon to give some kind of a, the RP can be involved in the process, or while drawing up the resolution plan, there is some kind of engagement with the authorities on the compliance aspects, or of whether there is facility for best judgment and all of that, so that there is a closure. Otherwise, the revenue cannot let go of its views. Whatever the amendments of law may come in, but futile litigation will continue unless a holistic solution is found. And with great minds like whom we've heard speaking today, and many more who have contributed during at the time of who are involved in this on a day-to-day basis, I think we should evolve a solution rather than let this be a burning issue forever. Because otherwise, whatever amendments keep coming about in the IBC would still probably not fix the problem in its, there is this, as these judgments have revealed, there is a discomfort. And as Mr. Sankaranarayanan has pointed out, how does somebody not evade, how does somebody who evades tax, who doesn't do what they're supposed to do, get away, go scot-free? How do we, these are at, it'll raise certain existential questions in many judges' minds. So that's what we would anticipate. Thank you so much. And thank you, Mr. Natarajan, and Mr. Chopra, and of course, apart from Mr. Rajendran, Mr. Patsati, all of you who have enriched the session with your questions, comments, and made this possible as a extremely enlightening and engaging session. We didn't know how the time flew. Thank you so much, and hope to have more webinars like this and more.
Thank you. Thank you very much, ma'am.
Thank you very much. Thank you. Bye.
Thank you. Thank you.
Thanks.
Thank you, Srinath.
Thank you,
Thank you,
sir.
Parsati. Thank you.
Thank you, sir. Thank you.
Thank you, Sankaranarayanan. So we'll close the session, sir. So you can stop recording the session.